Good evening, everybody. I hope you were all doing well. Survived April 15th, which was tax day. Hope you're looking forward to a meaningful Easter weekend if you celebrate. If you're celebrating Passover, hope you get through the rest of it. Again, I hope everybody's doing really well. I'm in Atlanta. The weather has been really nice. And it's just been a nice change from not too long ago when it was really, really cold. We're not at the point now where it's really hot yet, so it's cool in the evenings and warm in the daytime, mid 70s. Couldn't really ask for too much better. So I hope everybody's doing well. Been a really, really busy few weeks for me. I had an unusually high number of hearings last week. I was just crazy. Like I had 2 hearings on Thursday, 2 on Friday, 4 on Monday, 1 on Tuesday. I probably had more hearings than I can recall ever having in any one week period of time, but most of them went pretty well, I think. So I think we'll be in pretty good shape, but I'm glad this week that was last week. This week was not nearly as bad. I have one tomorrow, but it's stressful. But anyway, I hope you have some good comments coming. Let's come jump into that. Jim Badal, who it was nice of him to say that he's got approved. Took him 3 months on initial. He is 60 years old, and he wanted to thank us for the videos. And look, I think a lot of the comments that I get, add to the discussion. Jim, I really appreciate you taking the time to post this. And again, if you feel appropriate, please leave me a nice review. You can go to, I'll put the review page up here. If you're watching, that's where you would leave a review. That would be great to do that if you don't mind. But bottom line is that, this is all difficult. Jim said that medical evidence and going to the specialist, updating Social Security was the key. He got approved early. I think we're seeing more of this where people who are being approved early with really strong cases, Social Security wants to get those cases approved and closed. So I think that we may be seeing more of that. So especially if you're over 55 and you have a solid argument, then go for it. I think that, there's a better chance now than there's been in a long time to get approved early. And Jim, thank you very much again for commenting. Congratulations on your win. Christina, one of our regulars, is here from California. Christina, I hope you're doing well. Thank you for tuning in. Leanne says she got a notice from SSA that they have a determination about my case was selected for a quality review. What does that mean? How long will it take? It just means that periodically, when Social Security, either at a hearing level or at the administrative level, issues an approval, there is a review process that they will randomly choose files. I know some of it's random, some of it's based on the type of impairment, and another pair of eyes will look at it. I've had it happen several times. I think a gentleman who's a regular here posted that he had this happen. I've never had it reversed. But, they're going to look at it to make sure that the decision maker, if it's either the adjudicator or the judge, properly followed procedure, made the right decision. If it's the administrative or recon level and they decide that it was prematurely approved, they'll just put it back in the system and you may have to go to a hearing. Hopefully, like all my cases, you won't. But this is just a review. And I will tell you that, as you all probably know, if you're watching the news, that the president feels like there is a lot of fraud in the Social Security system. I personally don't see it. But again, I only deal with the disability part. I'm very selective in my cases. And there may be evidence of fraud elsewhere. I know one area where there was fraud was people would call up Social Security and change the bank account where their direct deposit would go. And I think there was some fraud there. Whether it's worth upending the entire system, that's for others to say. I think it may be a little bit of overkill, but regardless, there seems to be a real focus on combating fraud. I think that, we're going to see more reviews. There is a perception, there has been for a long time in Congress, that a high percentage of people getting approved are not deserving. Again, not been my experience, 35 years of this. That has not been my experience. I think there are far more people who are not approved that should be approved than the other way around. But I think that, we may see more of these quality reviews. We may see more continuing disability reviews. What that means to you is when you're applying, or whether you've been approved or not, You got to keep going to the doctor. You got to keep building that medical record. I wouldn't get paranoid about it, but I would say that, the odds of a review at some level are increased, especially if you're under 50. So, be prepared for that. And honestly, if you think about this in terms of other types of disability, like long-term insurance or long-term disability, rather, or workers' compensation, there are, like workers' comp. My wife does it. They send investigators out. Long-term disability companies send investigators out. So it's not unusual for the payor to want to make sure that there's nothing funny going on with the payee. We just are not used to seeing it in the Social Security system. I think people feel like because Social Security, they paid into it, why should they be subject to this type of review? But, that's more the norm than the exception. Again, that being said, keep going to the doctor, keep your own medical file, and, assume that you might be reviewed. You keep a pain diary, keep a symptom diary, so that if you are reviewed, then you have an opportunity to defend yourself. The one I'd say real negative about the Social Security system being reviewed is if, let's say, you got approved for benefits and they send you a continuing review, and you want to get an attorney involved, then you have to make a decision. If you want benefits to continue while you appeal, then you can't get an attorney on a contingency fee because there's no past due benefits. If you don't want benefits to continue, you've only got 10 days to make that decision, and they stop, then you may be waiting a year and a half with no money coming in, but you can then hire an attorney. So it forces people, who have been approved to make a decision of either no money coming in so they can hire an attorney, or money coming in while they appeal, but no way to hire an attorney without paying directly up front. So that's a real problem. In the workers' comp situations, it's sort of different because the way those cases are structured. In the long-term disability, I think if they cut you off, I don't think you have the option to have benefits continue. So, like I said, I think it's just you want to be prepared for it. But having a review of benefits is, like I said, more the norm than the exception. But it does have some social problems in the Social Security world. Okay. Stargirl says, hello again. Hello, Stargirl. I have new medical evidence that lends itself to amending old medical records. How can I go about making these amendments, and could this process be expedited with an attorney? I mean, I think in general, an attorney would probably have a better idea of how to structure such a request. And when you say amending old medical records, if you mean going back to a prior doctor and saying subsequent information, subsequent testing has showed that that provisional diagnosis you made 4 years ago was wrong, will you change that? I don't know that doctors are all that willing to do that. I've had people reach out to doctors to ask them to change something in a record, whether it is, a allegation or a suspicion of alcohol or drug use, or, or some comment about the person who was working. I mean, things that are just factually incorrect. Doctors don't like to be questioned on that sort of thing. So I don't know, again, attorney or no attorney, I don't know that you're going to have much success having a doctor amend a prior medical record. I think that if there's something new that shows that a prior record is inaccurate, you can make that argument either to Social Security or to a judge in a written format. Again, let's just give an example. Let's say that there was a allegation of back pain, but there was no evidence, at 4 years ago of the reason for it. And the doctor basically said, I think this is a muscle strain. Well, lo and behold, 4 years later, you have an MRI that shows severely herniated disc with, nerve root compression. And setting aside the question of whether that existed 4 years ago, you could make an argument that certainly as of the time of the MRI and likely for some time before then, the reason for your back pain was not an unknown, not musculoskeletal, not in your head. It was because of an organic problem. But again, I think you can make an argument to a judge. Judges in disability evaluate medical evidence. And so if you can prove that a prior conclusion or prior assertion in a medical record is incorrect, you can do that in writing, do that in an argument, and a judge can disregard it. But I think you're not going to have a lot of success getting a doctor to change things. And honestly, part of it, I think, is that doctors are probably very concerned about malpractice issues. Not misdiagnosing can be malpractice, and so I think that they just are inherently concerned about that. So I guess big picture would be, my thought is if you have new evidence, especially that's more recent, maybe more recent in terms of your onset date, you can make an argument that a judge should give that new evidence more weight than the old evidence, or even controlling weight. But I think that's probably what the argument you would want to make. And again, whether you have an attorney do it at the administrative level or at the hearing level, that's up to you. Certainly, if you go into a hearing and you're trying to make an argument about a weight of evidence, I would think an attorney would be of value. And certainly, I would not tell anybody to do a hearing without an attorney. At the recon level, initial recon, that's a judgment call on your part. But I do think that is, in my opinion at least, a hearing would certainly require the services of an attorney. But I think this is more of a legal argument than trying to get a doctor to change his or her tune. Jenny, who's one of my clients, we just got approved. This is awesome. We got approved at recon. We had a good case, obviously, but I was very happy about that. And I know Jenny and Jen and my staff and myself, we have been a lot of communication over the last few months, and I'm glad that it worked out. And this is an example of when I do a recon, I will make an argument in the recon. Did that here? It worked. And so, you can always make your arguments at any stage of the game. Certainly when you're doing your appeals or initial application, if it's a grid rule argument, if it's a listing argument, if it's functional capacity, make that argument. I think it's really important. I've often talked about the importance of a narrative in a Social Security case, meaning that you need to tell your story and how you got from being productive and working to not working, and why this has been so devastating to you in many areas. You want to have this narrative there. But in addition to a narrative, you can have a legal argument. I mean, there are three ways to win a disability case. One is to meet a listing, which is, kind of rare. It's hard to do. The second is a functional capacity argument. The third is a grid rule argument. And especially now that I think Social Security is looking for the clearer cases to approve, the grid rule argument can be one that is very powerful. If you're over 55 and you've got something physically wrong with you, I'm almost always going to make a grid rule argument, because the grids very likely apply, or you make a functional capacity argument. So, I think you want to be thinking in terms of a narrative. You're telling your story, and then thinking about connecting the dots, which is to put that narrative into the context of one of the theories of disability that Social Security recognizes, usually either functional capacity or a grid rule. But Jenny, I'm glad that it worked out for you. I know you've had some tough times this year, some other things going on in your life that we've emailed about a little bit. And I'm glad that this came through, and this maybe hopefully will turn the tide. Okay. Slowpoke says, well, now I see why you're slowpoke. You had 4 knee surgeries, including 2 knee replacements. Last year I started having knee pain again. I also have arthritis in my back, elbow, and hand. Be 59 with the grid rules apply. Absolutely. Because again, at 59, which means you're over 55, if you can show that you're not able to perform light work is defined as standing and walking 6 out of 8 hours, lifting 10 pounds frequently, 20 pounds on occasion, assuming no transferable skills because of pain or other non-exertional problems. I think this would be a pretty compelling grid rule argument. I think you could make it's certainly logical to assume that a person who's had 2 knee replacements, as well as arthritis in the elbow and the hand, is going to have trouble lifting, 10, 20 pounds occasionally, or standing 6 hours. Perfectly reasonable. Those complaints would be reasonable. So I think that would be my first argument, in fact, would be the grid argument. So absolutely, I think the grids, that sounds like a pretty good case to me. And Jenny wanted to Jenny, just, again, I concur with that. Learn as much as you can, not just from me, but from other people as well. There are other people. I know Walter Knott's got a nice podcast or a nice live stream and videos. And my buddy Chad Brown is doing more of them. So there's a lot of people out there. So use all the resources. I mean, none of us has a monopoly on knowledge. I learn things from other attorneys, and you should too. Trish Wade says, good evening. Good evening, Trish. How are you doing? Rajul Hoke, I have a court hearing by phone on April 29th of back pain, schizophrenia. What are the questions if the judge is going to ask you? I think that there are certain questions you're always going to be asked that you need to be aware of. Okay, so and I think I've gone through this before, but there's probably a video on it someplace that I've done. But big picture, you're always going to be asked about your past work. So you need to know over the last 5 years the places you've worked, the job you did, how much you had to lift, carry, what the mental requirements of that were. You're definitely going to be asked about that. You're going to be asked about basic, again, with back pain, functional issues, sitting, standing, walking, kneeling, crawling, crouching, stooping, climbing ladders, ropes, and scaffolds, climbing stairs, walking on uneven terrain, need for an assistive device. I think I mentioned lifting. How much can you lift? How much can you carry? Just all those functional things that that anybody would want to know in terms of your physical capacity to do things. And in terms of, and in fact, if you just type in residual functional capacity form Social Security, you will see all the physical issues that are necessary or that will be considered by Social Security. Mentally, with schizophrenia, obviously, schizophrenia, if those who don't know, is a mental health condition where people sometimes lose touch with reality. So I think that, as far as questions, I would suspect that the judge is going to ask about the frequency of the symptoms, the intensity, the duration, whether medication controls them or reduces them, that sort of thing. And I think that, it can be difficult because you're involved in it to talk about what those symptoms are, because it presumes that you realize after an episode that you were having a schizoaffective disorder episode. This may be a situation where you have a third party, a spouse, a friend, a former coworker, appear at the hearing to talk about what that person has observed about what you do, the symptoms you've got. But I think, again, the symptoms, and with schizophrenia, it's going to really be about, functioning activities of daily living, feeding yourself, paying your bills, paying the rent, managing your getting up and going to sleep, dressing, washing clothes, things like that. I don't know that with schizophrenia that your testimony is going to be as important as what the medical records say. So I think that, you can talk about all those things, but, you need it with the psychological, psychiatric records to talk about those things. So, but that's kind of what you're going to be asked. It's just really about your functioning, because ultimately with both back pain and schizophrenia, it's about your functioning and how these conditions affect your functioning. You don't win because of the diagnosis. You win because of the way these conditions affect your functioning. So I would think about, all the ways physically as well as mentally your functioning has been impaired. Matt F. says, I'm 49, turning 50 in June. I have neuropathy in both legs, walk with a walker, inflammatory arthritis in the spine, frequent falls, PTSD, major depression, panic attacks, work part-time under SGA. Okay, I think that's the same question there. Okay, so, and I'm sure your question is, do you have a case? Here's more. I take gabapentin, makes me drowsy, take Cymbalta and Vistaril for panic attacks, knock me out after stop working 3-4 times a day to elevate your feet. Okay, so I think that, obviously, the first thing I'm going to tell you is that at 50, your case will be stronger simply because you could meet the grid rule. And if you can show that you cannot do sedentary work, you would win. So you don't have to prove as much. So I think one thing would be at 50, your case will be stronger. But even without that, you have, having to use a walker, which again is going to grid you out at age 50 at sedentary, because you can't do light work with a walker. All these conditions are inherently, potentially disabling. You don't win, as we talked about, based on PTSD or depression or a label. You win based on the impact it has on your functioning. You talk about medication side effects, gabapentin, Cymbalta, Vistaril, all these type of things, and you're getting, it looks like, special considerations from your employer. So I think that, you've got a list of conditions that potentially are disabling. I think the medical record would be really important to see what the doctors have said about this. And if you can get one or more of your doctors to complete a functional capacity evaluation, that would sort of translate the medical issues and the medication side effects into work limitations, that would be very, very helpful. Again, 50 is going to make your case that much stronger. The part-time work, what I would do there is, if your boss or supervisor would be willing to write a letter, it could be a to whom it may concern letter. You can put it on a form or not. It can be just type it in letter that basically says that you are given special consideration, that you can leave when you need to leave. You can take an extended rest break. You can change your hours. These type of accommodations would not be normally available to somebody, but because for whatever reason they're giving them to you, whether it's you've got a relationship with the boss, or you previously worked for the company, or they just are being nice. I think if you could get something from the employer that talks about those special considerations, that would be very helpful to eliminate or to make that job non-SGA. Realize the numbers, the dollar that you earn, the 1550 or 1620 in 2025. That is one way to look at SGA, but SGA can also be inferred from the activity you're doing, regardless of what you're being paid. You could be doing volunteer work that is SGA. You could be going to school, that could be SGA. So the dollar is one way to do it, but there's other things. So you need to be able to address that. And it sounds like you're getting some special considerations. So the symptoms that you've described to some degree appear to be, at least potentially disabling. At 50, even stronger. But, all these things taken together, I think you can make an argument that the combined effect of all these problems, the medical issues, the symptoms, the medication side effects, would leave you without the capacity for competitive work. And again, at 50, look at the sedentary grid rules, and I think you'd have a pretty good argument there. So all in all, it sounds like, based on what you're saying, you've got quite a viable case there, Matt. All right, Sarah D. I've been diagnosed so far with chronic diabetes and anemia, celiac, currently healing knee injury, PTSD, severe anxiety. None of my treating doctors this day will fill out any forms. Let's see, how likely one with just medical records and a treating doctor's report, upcoming sleep study, all my medical records documented. I don't think you have to have a functional capacity form. If you asked me that question 10 years ago, I would tell you that it's really important. If you're under 50, I think it's really important. But if you can't get them and the doctors are willing to talk about, at least reference in the record some of the functional issues, or at least talk about the severity of the condition. So look, let's just talk about diabetes. Are you type 1 or are you type 2? If you're type 1 on insulin, that is it's going to be perceived as extremely serious by most judges. Oops, I lost that there. Sorry about that. I hit a little button there. If you're type 2 on pills, not as serious. Type 2 on insulin, more serious. So it's going to kind of depend. If you're over 50 or under 50, that's going to make a difference. Celiac disease, is that going to really be disabling? It means, obviously there's certain foods that you can't eat. Is that inherently disabling? Probably not, unless there are other symptoms. To celiac disease, if you are properly maintaining your diet and avoiding any kind of gluten. The knee injury, is it something that is going to be resolve itself within a year? So you have that year duration or not? The PTSD, the judge would want to know about the trauma that underlies the PTSD. Was this some sort of abuse you had? Was it a one-time thing? Was it over a long period of time? Was it the military? I mean, you need more details. Severe anxiety, are you being treated by a psychiatrist? Are you taking psychotropic medications? Are you getting talk therapy? You need indicia of severity. So I think the real question here is, how severe are these conditions? And is the severity of the underlying medical condition consistent with the severity of symptoms that you describe? I think that's the way to look at this. So potentially viable case. You're 56 with, severe level of these conditions, very strong case. You're 43 with mild to moderate, much more difficult to win. Tara, okay, thank you. Tara, thank you for commenting. I really appreciate it. Okay, Courtney Stage on SSI, just 2013, hearing for fact next month. How often is judge taken away the disability someone has been in for over a decade? Again, you asked me this 3, 4 years ago, I'd say pretty unlikely. Um, I think what a judge is going to look at is, are you getting ongoing treatment? Is there any evidence of improved uh, capacity, functioning? Um, you know, Remember that if you don't go to the doctor, psychologist, psychiatrist, therapist, if you don't go, Social Security will assume if you're not going, there must not be a problem. So if there's not a lot of records there, that's problematic. Um, if you're on SSI, what is it for? Is it physical? Is it mental? Has there been improvement? Have you been to work? Are you working part time? You know, ongoing. It's kind of hard to say. I mean, the fact that you've been on for 10 years and now they're looking at it does not mean that they're not going to take it away. I mean, I just think that, you may have just been fortunate that they didn't review it. I think the medical evidence is going to really be a lot more important than simply the fact that they haven't looked at it before. But, hopefully they will not take it away, and you will find yourself, just with a ongoing disability payment. And you mentioned SSI. Is it SSDI? Is it SSI? I would try to get a copy of your exhibit file so you can see what's in there and make sure it's updated with the most recent type of stuff. But again, medical records are really the key to any Social Security case, I think. Jenny talked about that before, and I think so did the gentleman, Jim. What he said. This is what he said: the medical evidence and go to the specialist. Updating SSI was the key. I think that's applicable as well when you're undergoing, Courtney, when you're undergoing a review. Okay. I'm guessing that someone is you, St. Louis, had your second hearing today. They're surprised how different the second ALJ and first ALJs. So you had a different ALJ. So what St. Louis is saying is that, different judges conduct hearings very differently. Look, I had this experience a few weeks ago. I had a case. My client had gone before a judge with one of the worst approval rates in the country. I mean, probably in the bottom 5. Happened to be in Atlanta here, and she went, and the judge, to his credit, said, "This is a complicated case. You need to get an attorney." And so he reset the hearing. And I'm going in front of this judge who's just, like I said, terrible. He ends up taking one of the buyouts that Trump offered to a lot of Social Security employees. New judge, much more reasonable, much higher approval rate, much more pleasant to work with. He approves the case. So you have Judge A, who runs one type of hearing, Judge B, very, very different. And we were, like I said, we were approved. So, ALJs are going to have different styles. They should be some commonality, but a lot of times they're written. Okay, Vince says, "Good evening. I'm doing okay currently on day 36 of the 90-day Carnivore Challenge." They're interesting. Vince is a buddy of mine who is, his name is Pete Harris. He's a disability attorney in Nashville. I think it's Music City Disabilities, his website, if you want to check him out. But Pete and his wife went on the carnivore diet. And I actually had a chance to have dinner with them. I was up in Nashville, I guess it was almost a year ago, in May of 24. There was a convention, an Oscar convention, the Social Security Claimants Representatives. It was in Nashville. So I was up there, so I called him up, let's have dinner. So we had dinner, and he and his wife were in the carnivore, and they had lost, I think Pete had lost 30 or 40 pounds, and his wife maybe 25 or 30 pounds. He felt it was a great program. And of course, there are, different views about the carnivore diet, which is basically eating mostly meat. I personally am not a big meat eater. I mean, I don't mind it, but I can't imagine eating, meat, red meat every single day. Maybe chicken and fish I could deal with, but red meat probably not as much. But obviously what you're doing is you're basically eating just nothing but protein, mostly protein, not a lot of carbs. You put your body into what they call ketosis, which means it's burning protein and fat for fuel as opposed to carbs. And so it will cause the cells to release the triglycerides, which is what carbs turn into. It uses that up and you lose weight. People have lost a lot of weight. There are some that feel like it's not healthy in terms of the macronutrients or the effect on your cardiovascular system. Others say that, there's no evidence at all that that's the case. There's and again, I'm getting on this tangent here, but if you're interested, there's a very interesting book by a guy named, it's called Why We Get Fat. I forget. No, I'm thinking about it. Let me see who wrote it. Gary Taubes. His name is Gary Taubes, Taubes. He's written a couple of books. And his argument is that carbohydrates are the real killers. So, Vince, you're on the carnivore diet. I think it does work. Everybody I know that's gone on it does work. I think the problem is you just get kind of sick and tired of eating no carbs, because I think, we're just where we evolved. I think, we're going to crave that. And, if you can do it, more power to you. Like I said, for me, I could probably do chicken and fish, but even then, like, you want a piece of bread, you want a potato, so I think it would probably be difficult for me to do. But on the other hand, I understand why people do it. So way off on a tangent there, but Vince, I'm glad that you are losing weight and doing well. Elliot, lost my health insurance, had to go to a new neurologist, diagnosis the same. Should I upload the report in federal quality review with this confused thing? I think if you've got new information, go ahead and upload it. I think that the more information you give them, the better. So I would upload it. Avsena, good evening. And I now owe you a phone call. It's been kind of a crazy week. We had some family stuff going on. Somebody in my family got sick, and we sort of had to deal with that. But I know I owe you a phone call, and I will do that in the next couple of days. We've got a hearing tomorrow, either tomorrow or Friday. But I know you're going to tune in, and I figured you might ask me. I know I do owe you a phone call, and I will get to that. What is wrong with the Braves? Says Shub S Hub 281 Shub 281. That is a very good question. The Braves, Atlanta Braves, if you follow baseball at all, went into the season with really high hopes. They've been really good for a long time. Good manager, good players, and the first couple of weeks of the season, they just could not win for losing. They're terrible. I mean, the offense has been nowhere. And I think, part of it is, and I'm not going to spend a lot of time on this because nobody really wants to hear about it, but I think part of the problem is the Braves were built on the home run. They're not hitting home runs, therefore they're not manufacturing runs, and they get behind and they start to press, and that's that. They also had a high-profile Jurickson Profar, I think his name was, from San Diego, and he comes to the team and immediately gets busted for performance-enhancing drugs. He's out for like 2 or 3 months. So we'll see. We'll see. They got Spencer Strider back, one of their best pitchers. They did lose Max Fried in free agency. They let a couple other guys go that were sort of good clubhouse guys. We shall see. I'm not going to count them out yet, but statistically, they've dug themselves a hole. So we will see what happens. But that is my take on it. I haven't really watched too much. And this is actually another interesting point. Used to be all the games were on TBS, Superstation, and now they're on, like a pay. You have to get the streaming service, which I've not done. So I don't see as many games. So you don't follow them as much. It'll be interesting to see if their attendance suffers or the popularity suffers because of that. Anyway, back to business at hand. Do I mention I have many hearings? Are you finding you're getting more business as you're going live? I think it's definitely helped. I mean, we have a plan in my firm, and I work with a practice management consultant who sometimes is on here. And we get videos out on a fairly regular basis. I'm doing more shorts, doing more videos. We can use the live stream. So, I've been fortunate that I get a fairly steady influx of leads, people that are interested in having me review their case. I think the numbers have been, probably creeping up a little bit. One thing I have not done, which I probably need to do, is to publicize the live stream, buy some paid advertising on Google or Facebook to publicize it. Right now, I've got 120 people watching. I've had it as high as 200. I know Walter will get 700-800 people on his. Now, again, he sometimes gets really far afield, doesn't talk about Social Security, and talks about a lot of political stuff. And lot of side conversations going on in his. But look, I give the guy credit; he's getting a lot of people. So, always room to improve, and I'm always looking for ways to get more people to come on. On my signature file, it tells people, tune in. So yeah, I think certainly it's been good for business. More important, I just enjoy doing it. Whether it's good for business or not, I enjoy doing it, and it's a good way for me to get questions for other videos and just to sort of interact with people in real time, which is really kind of fun. And one thing Walter does, which I kind of like, is he'll actually have a phone, and I guess it's a separate number, and he'll like play them, they'll ask a question on the phone, and he'll play it on the live stream. The problem I've noticed with that is sometimes people just start blabbing and they can't get to the point. They'll give us, 5-minute warm up to their question. And I think, that's a little less desirable, but, might be something to look at. Kelly Brickner, yes, your husband is my client. Went up and down with our hope regarding this claim coming about a year. SSA is so chaotic right now. Yeah, it is chaotic. I mean, I think that, we are seeing a lot of personnel issues. I think a lot of people have left, especially some senior people. I think there's middle management people that are being reassigned to field offices. There is a lot of focus on fraud. They've been playing back and forth with opening the offices, closing the offices, messing around with the telephone system. I would tell you my overall observation would be that people over 55, I'm seeing an increasing number of administrative approvals. Like, your husband's been up on it for a year. So I'm seeing more approvals at initial and recon of people over 55. So that may bode well. At the hearing, I'm getting I would say, a very high percentage of those cases are being approved of people over 55. So I think that judges realize that, these are cases they're not going to be questioned about too much. I think the biggest hurdle that I deal with is, and I had somebody, read me the riot act in an email this morning, is, it's taking a really long time. And what are you going to do about it? And of course, there's nothing I can do to force an adjudicator to do his or her job. What I'm telling people is, once it's beyond 5-6 months, reach out to your U.S. senator. So Kelly, I would say that would be, one thing to look at doing. And I've got a video, you can ask Jen, she'll send it to you, about how to do it. But I would reach out to your U.S. senator and ask, for a congressional inquiry. That might get things going. But, again, given the age and the nature of your husband's illness, I think it's a good case. It's just getting Social Security to get around to doing what it's doing. I'll just give you a ridiculous example. I had a case that I opened 4 years and 7 months ago. Okay, 2020. I got paid on it today. Okay, this is a case that's been sitting in my office for almost 5 years, and I won it. I had to file a fee petition. 2.5 years in the fee petition. The case has been sitting for over 4.5 years. Finally got paid on it. Social Security is just a hot mess right now. They have a lot of people that are new. They have not enough people in some offices. It'll work itself out, I think, but this is just the reality of what we got to deal with. Okay, Alicia. Another one of my clients. Can you talk about hearing prep, what goes on generally? Yeah, I can tell you specifically. I mean, in your case, I know is coming up fairly soon, because I was looking at it just the other day. Not going to discuss the details. I'm just going to see if I have a date yet. Scheduled hearing. We do have a scheduled hearing. So your hearing, well, you probably know this already, is scheduled for July 7th. So what we're doing now is I have people in my office, Paola and Jen and Madeline in particular, are going to be updating the medical records. So we can pull the exhibit file. Let's just see if it's been exhibited yet here. Okay, so your file, I'm looking at it right now, has not been exhibited, meaning that they don't have exhibit numbers for the evidence. So in other words, there's a lot of evidence in here, a lot of medical reports, but there's no numbers attached to it. So generally, so before every hearing, what the hearing office will do is they'll say, okay, this medical record from this hospital is exhibit, 14F, pages 1 through 35. Then you have 15F and 16F, and most of the time it's going to be 20 to 30 exhibits. Until that's done, I can't really do much in terms of writing a pre-hearing brief because I can't reference a record. In other words, I can reference it by date, but no one's going to go double check that. So once we have exhibit numbers like 13F, 14F, I can reference 13F page 3 was an MRI, or 14F page 5 was an ultrasound, or whatever the case may be. So right now we're waiting for the case to be worked up. What we are doing, what I suspect Paola will be doing, is sending you a printout of section F of the file, which is where the medical records are, and you can see the dates of the records. Is there anything we're missing that you can see, that you can spot, anything new? We'll also be sending you some of the forms that they want us to fill in: current medication list, a work history form, recent medical treatment. So it's really about just, between now and July 7th, is really putting together all the information that they need so that the file will be complete. My goal when we appear at your hearing is to have the file completely updated so that there's nothing to be left open. The record doesn't have to be left open. The judge says, "Counselor, is the record complete?" The record is complete, Your Honor, and that we can go ahead and do that. And then then the judge can go ahead and listen to the case. Once the file is exhibited, I do a kind of an overall overview analysis of it, so I have a big picture understanding what's going on. And then at that point, you and I will talk. We'll go over what's going to happen at the hearing. We'll go over information about the judge. Let's see if there's been a judge assigned here yet. There is a judge assigned to the case, so we'll go over the judge, what I know about that judge, what other people are saying about the judge. We'll go over all that kind of stuff. We'll go over what actually happens in the hearing in terms of from the time that you get on the phone until the time it's closed out. The questions you're going to be asked. We'll go over your past work. We'll go over physical and non-exertional limitations. So it's really, we're sort of in stage one of the preparation part, because again, we don't have the exhibited file yet, but we'll get everything ready so that when they do exhibit it, it'll be ready to go. But that's what's going to happen. Is just, my goal is to get your file, completely ready. I'll have a very clear idea what's going on. I'll do a pre-hearing brief, and then you and I will go over, testimony and the questions and the stuff that I always do in my pre-hearing calls. Let's say if we're talking about how long you can stand, I'll say, okay, Alicia, how long can you stand? Any one time? Not very long. No, it's got to be, is it 5 to 7 minutes? Is it 15 minutes? How long can you walk, or how far? I can walk about 15, 20 minutes. Okay, realize 15 to 20 minutes, that might be a mile. Can you really do a mile? Well, maybe not. Maybe it's only half a mile. Just stuff like that. We just go over these things. People a lot of times overestimate their capabilities, and I'm not going to tell you what to say. I'm just going to, if I hear something that seems inconsistent with what I believe the evidence shows, I'll ask you to rethink it and make sure that we're clear on that. So all the questions I know we're going to get, I'll have you prepared for. And then, we'll just go over some of the other questions that I think I'm going to ask that I think would be relevant. And, I'll also be evaluating the way you talk to me in terms of, do you come across as being a reluctant claimant, somebody who doesn't want to be here, somebody who'd much rather be working, or is there a sense that you've gotten invested in, I'm not saying you have, I'm just saying in general, if I sense that somebody is invested in the idea of being disabled, they sort of see themselves as a disabled person, as opposed to somebody fighting it every step of the way, in my opinion, your case will be a lot stronger if you come across as being reluctant. So we'll go over that and have, some things you can say to position yourself that way. So that's kind of big picture, what we'll do to prepare. Okay, I'm just white. Should I include my medical records in my initial app, or should allow SSA to request the documents from your doctors? You can include them, and when you look at the application, you can upload things. What I would probably do, generally speaking, if you're going, let's say you have VA records or a big hospital chain, Social Security can get those pretty easy. There's a system called the HIT, or Health Information Technology. They can request them electronically. They really prefer to get them themselves. If you've got them, if at all possible, if you could reach, let's say you file your application and 3 or 4 weeks in, if you can get an adjudicator to call you back, do you have these records? I've got them. I don't like duplicate records. And so my initial thought would be let them request those records. But it would be much easier to say that if I felt there's any confidence, you could find out what they have received. If you have an attorney, the attorney can find out, so we can log in, we can see. But as a non-attorney doing it on your own, you won't be able to see that. And the problem is getting somebody to call you back can be a challenge. But if you can get them to call you back, or if you can fax them a letter, you'll get a letter at some point saying, I'm with the name and the fax number of the person and the phone number of the person who's doing the adjudication. You could fax them and say, do you have these records? If not, I can provide them to you. Not perfect, but so my big picture answer is, overall, I think it's best to let them get those records because they want to make sure that they've not been sanitized or scrubbed, stuff's been taken out. If you can possibly find out what they've got and they don't have it, then you could submit it. But that's more of a practical problem than it used to be. But I'd say overall, let them give it a shot first. But do follow up to see if you can get information that they've received it. I know this is kind of a wishy-washy answer, Dwight, but that's the best I can do because it's just, this is one of the situations we're dealing with. Kelly tells Vince, good luck with Carnivore. Absolutely. Vince, you'll have to tell us how it's going. I think you said you'd already lost some weight. You're on day 36. Now, how much weight have you lost is the question. How are you feeling? And what do your blood levels look like? Those are questions. My case is this is a second quality review decision. Usually, yeah, if it's in quality review, a decision's been reached. Probably pretty high. It's favorable. They're not going to do quality reviews and unfavorable decisions, generally speaking. So my gut would be it's favorable, and it may take 2, 3. Here we went a long walk today. 2, 3, 4 weeks. Yvette Castillo. I'm nervous because I'm waiting for my case to be approved. They're waiting on some of my medical records. Well, again, I hope it is approved. Don't assume it will be. I hope it will be, but you need to get a decision in your case. Obviously, waiting on some records. Now, again, you didn't say where you're at. Are you at the hearing stage? You're at the administrative level, initial or recon? And I would tell you, if they're waiting on some records, one of the things you can do is contact the provider and make sure that Social Security's got the correct mailing address. Encourage the provider to cooperate. If you can get the records yourself, maybe send those in. Again, I think you got to be your own advocate here, and you could, pursue that to some degree. That might help. Okay, Colby Overhagen. When filing for SSI, if I'm going through my work, they're helping me file for it. Is it faster than me doing it myself at all? So it sounds like if I'm reading between the lines, you may have a long-term disability claim. The long-term carrier assigned a non-attorney rep to assist you to file. Is it faster than doing it yourself? Probably. Just because they do that all the time, the non-attorney reps. Now, the real question in my mind is, do you want the non-attorney rep to represent you in the Social Security case, or do you want an attorney? Realize if I'm reading this correctly, you've got long-term disability and you win disability, of course, the benefit is going to be the insurance company. They're not going to have to pay as much because whatever Social Security pays, that reduces what long-term has to pay you. The advantage of getting the Social Security is, many long-term policies have a limit, let's say 2 years or 1 year or 3 years, especially for certain types of mental health claims. Or if they cut you off, you got Social Security in the background. You get cost of living increases with Social Security that would cause your payment to go up. Um, I think that there's a lot of reasons to get on Social Security. And again, given that when you have to pay them back, this is a big one, you have to pay them back the lump sum that Social Security awarded you for those months when you were also getting long-term disability. That's going to be in your policy. You don't pay back the attorney's fees part. So when I always tell my clients who are getting long-term disability payments, if you hire me, essentially the insurance company is going to pay me. You don't have to pay me because you don't have to pay them back money you didn't receive. So, you pay them back. Let's say that my fee was $5,000 and you pay them back 20, and the total past due benefits is $25,000. You pay them back 20, not 25. So they're paying my fee. So if you wanted to get an attorney as opposed to a non-attorney rep, it won't cost you anything. So that's something to consider. So, but as far as getting the application filed, probably a little faster because they're used to doing it. Whether it will be more accurate, different story. Now, I will tell you that in my office, when somebody wants us to file an application, my goal is to get it filed as quickly as possible because I want to get as much back past due benefits as possible, as I can. Every once in a while, somebody says to me, hey, I would like to look at the application before you file it. Absolutely fine. I'll send them a draft. And at that point, they'll say yes, or let's make these changes, and we'll actually file it at that point. So, if you're interested in seeing what they say, and certainly I'll make a copy of it. And if we have to supplement it later, we'll do that as well. But I think I would try to get a copy of what was done on your behalf. Again, some of the non-attorney rep firms that these insurance companies use are perfectly fine. Others are a little more questionable. I'll just leave it this. Again, I think you get what you pay for. And I think that, in general, a law firm is going to probably give you a little better quality of service than a non-attorney rep, my opinion. Non-attorney reps would generally back off when an attorney is hired. So I had a case just this week. Somebody had a long-term disability policy. A non-attorney rep filed the application. She wanted me to take it over. I contacted the non-attorney rep. They withdrew, waived fees, no problem at all. I've also had at least two of these companies hire me, and this is not recently, last probably 5-6 years ago. They hired me to handle their hearings because they don't do hearings, and so they hire contract attorneys to do hearings. I always treated these cases the same way I treat my own case. Properly prepped it, was ready to go. I also know attorneys who do these contract hearings who spend about 15 or 20 minutes preparing. It's just, that's what you're going to get. So you have a little more, I think, a little more say into what's going on with an attorney as opposed to a insurance company provided non-attorney rep. My opinion. Others may disagree. Your mileage may vary. That's my opinion. And it's a long answer to a short question, but if you want to have them file it, not a problem. But I think you need to think about whether you want that entity or an attorney to represent you going forward. Christina says, don't forget to like, share, comment, and subscribe. Absolutely, please. Vince is responding to Kelly with the Carnivore, 1 meal a day, fasting 23.5 hours. I would have a hard time with that, but Vince, go for it. But you still haven't answered the question, Vince. Have you lost any weight? And you're feeling better. That's a good thing. But I think most people go on the Carnivore to lose weight, or maybe get their blood sugar under control too. Madeline from my office. Good evening, Madeline. How are you doing? Gigi, I'm 66-year-old, been denied twice according to me what type of questions. I just went over kind of the questions you're likely. You didn't say what the issues are, physical or mental, but there are certain questions you're going to definitely be asked. Go back about 5 to 10 minutes here. Someone asked me about the questions likely to get at a hearing, and I went through it in detail, so I'm not going to repeat it. But if you're watching this on replay, just go back. I went on right now. We're at minute 54, so I think probably at minute 45 or so is when I went through that. So I'll go back and listen to that. Yvette, I had my hearing in 3/5, still waiting because medical records. So you've had your hearing. It's been almost 2 months now, or it's been 6 weeks. Medical records are not clear, still waiting for the report. Why is it taking so long? Again, if they're waiting for medical records, the provider's got to provide them. And sometimes the judge will send the records out to a medical expert for analysis and review. That could be, just because they don't have enough people. But it's just, I think if they're waiting for records, you're waiting for records. Sometimes providers are just, health providers are just not real good about responding to that. All right, My Hero Macadamia. Okay, I was due for a CDR in August. I haven't received one. SSDI for schizoaffective. Should I be worried? Honestly, my feeling is no news is good news. As long as you're going to the doctor, I wouldn't read anything into the fact that they've not given you one, but I think you need to be prepared. But no news is good news. If they're not contacting you, maybe your file is coded to say this is not a file that needs to be reviewed very often. That may be what's going on. But I would certainly not reach out to them. Let them contact you. Give an updated opinion having spondylolisthesis, or what we call a slip disc, being a 53 and disability, firing restless employees, you lose the adjudicators for reviewing your case. Okay, so yes, it is a possibility that the adjudicator will move on. I realize the adjudicators work for the state you live in, not for the federal government. The government pays their salary, but they're working for the state. Now, the working conditions at these state agency offices are not great. So, there is some turnover there. And, you may get a different adjudicator. There's nothing you can do about that. That is a possibility. Spondylolisthesis is a significant back issue. Back issue being 53. Again, if you're looking at the grid rules, the sedentary grids are going to apply, meaning you've got to show you'll be limited to sit down or sedentary work, which actually, to be more accurate, is standing and walking up to 2 hours a day, sitting 6 hours a day, lifting 5 pounds frequently, 10 pounds on occasion. That's how sedentary work is defined. So, does the medical record support that level of impairment? And if you are at that level or worse, then the grids would apply. Spondylolisthesis is a medical diagnosis. It is not doesn't tell me anything about how the symptoms are. Do you have numbness radiating to your legs, one leg or both legs? Does it affect your walking? You need an assistive device like a cane or a walker. How long has this been going on? Are you a surgical candidate? Are you on long-term pain management? A lot of questions, you see. So, just having the word there, the diagnosis, doesn't tell me enough to be able to say, but it helps that you're 53. It would be better if you were 55, but it does help to be 53. And I've won back pain cases for people at 53 because I can argue that they're limited to sedentary work or less, and therefore the grids on the 201 series, the sedentary grids would apply. If you're not familiar with the grids, here's a link to my website, gridrules.net. Just go to gridrules.net and look up under sedentary. You'll see the different categories, 201.02, 0.03, and it'll talk about, education, past work, transferability of skills and things like that. But, find which grid applies, and that's what it would be. It would have to be one of the sedentary grids. So, okay. Lulu, let me go ahead and change this over here back to I'll put this one up there for now. Okay, Lulu says, I was told my mental health examination was favorable. However, I still have to go for a physical evaluation with them to see again what favorable mental. Well, basically, first of all, you need to look at the report. My experience has always been that a mental health consultative evaluation is more likely to be beneficial to you because the doctors that do these are typically practicing psychologists. They don't have a bone to pick. They don't have a dog in the fight. And they're used to seeing people with mental health issues. And they tend to be a little more open to what you have to say. A physical CE is a lot of times done by a industrial clinic doctor. Not always, but these are doctors that work for insurance companies and they use them to deny claims. So their mindset going in is that this person is not qualified for disability. So I find that the physical CEs are often pretty useless. I've looked at enough of them. In fact, I was looking at one the other day. It didn't say anything. It said nothing about the person's functional limitations. So many of the times the doctor is not really qualified to do it. And, many times they don't really say a whole lot, or my client will report that, the doctor spent 5 minutes with me and was looking at his phone the whole time. He produces a 7-page report, which is probably copied from somebody else. So I would make notes as to what happened. I would try to get a copy of the psych CE report so you can see what it says, and the physical CE report when it comes down. But you can certainly ask a judge to give it less weight if it's not favorable to you, assuming that there's a flaw in the report. But it is that's part of the process. And like I said, my experience generally, in a very general rule, is that mental health consultatives will either be neutral or they may help you a little bit. Physical consultatives usually are not going to help you, and neutral at best. So that's sort of my take on it. Christina says, please leave a 5-star review. Thank you very much. Yes, please. Whether if I helped you as my client or as a viewer, like some of the people have been nice enough to talk about, those reviews really help me build my practice. So I would really appreciate it if you would do that. Yes. Thanks, Christina, for reminding everybody. Okay, let's go to the next here. Colby, I've learned getting a letter from a doctor. If you can get your doctor to do a narrative report or fill out a functional capacity form, that can be very, very helpful. Because again, it translates the medical issues into very specific work limitations. So absolutely, I think I would, if you can do that, I would try to do that. All right. Let's see, we got next here. Karen says hello. Hello, Karen. And Karen says hello again. Hello again, Karen. Mark says, good evening. Mark is one of my clients. And Mark, your file, I just looked right now, it says decision writing process since March 27th, so it is still in process. Hopefully we'll have a decision soon. Again, the amount of time it takes for a decision to be written is not any clue as to what's going to happen, because it just depends on how busy they are. But they're in the decision writing process, so at least we know it's moving along. But it hasn't really been, the status has not been changed since March 27th. So we are now April 16th. So it's been, 3 weeks or so. Do I need a real ID? I do not know. To enter normal order. I think, I just don't know. I mean, I think that I've not heard that you need a real ID or an enhanced driver's license to enter a federal Social Security office. Let's see if there's anything online here. ID to enter Social Security office. It says here, I'm just looking, U.S. driver's license card or Social Security card. I don't see, let's see, let's just see if I need a real ID. That says, well, real ID compliant license. A real ID is a type of license. According to Google, if Google's right, it's not necessarily required for a Social Security office. They want proof of identity. So the sense I get is that you will not need a real ID, but it wouldn't hurt to have one. If you can get, if your state issues them, then that's going to become the norm. So probably want to go ahead and get that. But it doesn't appear you need one right away, even after March 7th or May 7th or May 17th, rather. What's your opinion on a spouse registering as a claimant's rep in order to access ERE? The question here is, and so what John is asking is, as an attorney, I can access the Electronic Records Express, which allows me to communicate with Social Security electronically. Back in the day, I had to go through training and ID verification. Let's see if there's anything about that. I don't know what you need to do to register for that now. Let's see how to register. How do you could try, you can call, there's a number here, 866-691-3061. Call that number and ask them if your spouse can register. Um, I think the one thing, that I know that when I did it, I had to go through a training program. They gave me this handbook and everything. They obviously don't want people uploading junk that they shouldn't be uploading. Um, it would certainly make life easier if you could do that. Whether you can or not, I don't know. I just don't know the answer to that. You need to look a little further into it. And again, that number I just gave you would be what to call. Again, give you the number again. Would be 866-691-3061. And I would ask them, what we involved in registering my spouse as my representative. You would need to submit a form 1696-1696. Look that up online. That will allow them, Social Security, to communicate with your spouse. And if you later on get an attorney, your spouse would need to withdraw and waive fees. I learned that the hard way. I had a case that I put a lot of effort into, a couple of hearings and everything. And my client's brother had registered as the rep and never withdrew. And so the judge denied my fee agreement. And I couldn't get the brother would refuse to withdraw. And I've never gotten paid on this case. And I probably never will get paid. I filed a fee petition, hadn't heard a word from it. So, it's just, I got screwed out of a fee because from a person I put a lot of work into, because this guy, this idiot decided to file as a representative, and I didn't even think about that they would count that, but they did. So, just to be fair to your attorney, if you get one, I would tell you to just withdraw if you do get an attorney, if you can do this. Okay. Rumham says, it's confusing because I feel like they want you to be bedridden to get it. Like, yeah, I can do laundry in a good day. Doesn't mean I can function the job. Yeah, I think that you make a good point, and that is that there is, a level of impairment that you have to be disabled. I don't think it means you have to be bedridden. Although I think that if you're under 50, it gets kind of close to that. If you're over 50, it's not as bad. But yeah, they expect you to be pretty bad off. I mean, there are some really simple entry level jobs that really, it's reliability is the big issue. And you need medical evidence. It's not just you saying I can't be reliable. You got to have a doctor saying this person has irritable bowel and has to use the restroom every 45 minutes. Well, that translates into an unscheduled break, or this person needs to lie down because of pain, back spasms every 4 hours, 3 days a week, or something, whatever it may be. But you've got to have the evidence. But yeah, if you're under 50, you have to have a way high level of evidence. If you're over 50, here, if you're over 55, not nearly as much. So yeah, they make it difficult. They do make it difficult. If I receive California disabilities more than SSDI, which is retroactive to receive this as long as SSDI. I think that's the case. I think SDI offsets Social Security, I believe. I don't know for certain, but I think so. I would contact somebody in the SDI office and see if they can tell you, or do your own research on it. I see it sometimes, but usually the offset's not enough for me not to take the case. But I believe there is an offset with SSDI and California SDI. Okay, I think I already answered that. Matt is an ADA. This is the gentleman who's working less than SGA, works a desk job, can't sit for more than an hour without a break, an ADA accommodation. Yeah, an accommodation, doctor says, okay. An accommodation takes you out of competitive work. So if you have an ADA accommodation they're providing you for, that would be less than SGA level work because it's accommodated, and that's not competitive work. Okay, Steven says, dentist keeps giving me x-rays. For dentist, I have to pay for at least one of these x-rays. It's reckless as being that I'm an SSI. Maybe I'm losing context, Stephen. I don't understand what you're asking me. Are you thinking that the dentists see Medicaid and they see there's a cash cow and they're doing x-rays on you because they get reimbursed for it by Medicaid? not sure what you're asking. I'm sorry, but that seems to be what you're asking. Okay. Yolanda Mitchell is, I'm a kidney transplant recipient and an SSDI since 2005. At the present time, transplanted kidney is failing. I'm sorry to hear that. After 17 years, I've been currently being evaluated for a second one. They start the process regarding Medicare. I don't think so. If you're on SSDI, you're obviously eligible for Medicare, and I don't think they're not going to cut you off if you're on a transplant list. So assuming you've not been cut off, there's nothing you really need to do. After your second transplant, they'll look at it to see, how much of your functionality has returned. But I don't think you need to do anything if you've not been cut off. Courtney has applied for DAC benefits disabled adult child. Hearing next month. Tonight, OTR takes a day or two to recover after going in public. So, again, normally if a judge denies on the record, they don't tell you why. Now, maybe the gist of your argument was you take a day or two to recover after going out in public, and the judge denied your on the record. Do you know that's the reason why? Does the judge want to see more evidence about that at a hearing? That's kind of my thought. So I think TBI obviously is going to be brain scans. It's going to look for lesions and things like that in the brain. And if you've got, a neurologist who's talking about, some of the functional issues that arise from your TBI, then that would be very, very helpful as well. Okay, now we're back to the carnivore diet. St. Louis says, try to limit my meat by doing it with plant-based meat too. Plant-based ground meat, really good taste. It seems just like ground beef. Never had it. That's actually interesting. Never had that. I see it at the store sometimes. Maybe I have to try it. I think I tried one of those Impossible burgers one time. It was not like hamburger, that's for sure, but I guess it's better than nothing. Beef, Vince eats beef, eggs, chicken, cheese, 0-calorie drinks. Not a big fan of the 0-calorie drinks. I don't like those artificial sweeteners. That's just me, but I'm not a big fan of, that stuff. I just think it's not particularly good for you. But interesting to see how it works, Vince. Okay. Charles got SSI at age 50 with severe stenosis, divisional disc disease, blah, 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 fusion. Let's see. At hearing, you lost, but got SSI at 50. Not sure if you lost SSDI, then you got SSI at 50. So the real question in my mind would be, did they approve you as of your 50th birthday? Is that what you're saying here? Jackie, I've been eating a carnivore diet for 6 years, lost over 140 pounds. Got rid of type 2 diabetes and a bunch of other issues. Work well. That's amazing, Jackie. That is incredible. 140 pounds, got rid of diabetes. I mean, that's pretty impressive. I got to tell you, that's pretty impressive. If the ALJ remand, the order from the Diogenes asked if the remand order from the Appeals Council of Federal Court says that the judge needs to have a medical expert. What does that mean? Basically, it means that you need to have a medical doctor to come in and interpret the medical records. Pros and cons. If you have an attorney, the attorney can cross-examine the medical expert, the ME, but many judges are going to basically take what the ME said with, as being the truth. Obviously, there's another vocational expert there. But, the medical expert judges are going to often go with what the medical expert says. So thank you very much. I was with this person at the doctor today, and I hope we've turned the corner, but it was, it's never fun to see an older relative not doing well because you just, there's not a lot of reserve there. And hopefully this situation will resolve itself in a favorable way. LinkedIn user says, my broadcast is amazing. Thank you. Appreciate that. Your willingness to share your knowledge. Okay, great. I appreciate that very much. LinkedIn user, whoever you may be, but thank you very much. And again, if if one is so inclined, please leave me a review. I would really appreciate that. So I put in the crawl how to do that. That would be very much appreciated. Okay. Karen, Karen kept saying hello, 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 Karen. You have central cervical stenosis, and if I fall because my wheels are weak, my balance, maybe your legs are weak. I don't know what a wheel is. My balance is bad. I have seizures, blurred, double vision, have small vein disease in my brain. Okay. So you've got a lot of stuff going on. So cervical stenosis in the neck means that the spinal cord is being compressed there. That can often cause numbness in the hands and the arms. Sounds like you've got some issues in the lumbar spine, that you're a fall risk, which again would vocationally mean you to avoid dangerous, hazardous equipment, ladders, ropes, scaffolds, things like that. Poor balance. So it sounds like you're right there, maybe limited to sedentary work. So if you're over age 50, got the grid rules to look at. But if you're under age 50, you have seizures, blurred and double vision, a small vein disease in the brain. And again, the seizures, the double vision, and the small vein disease are not exertional. So again, you can be younger and have these things. It just comes, seizures are always tough because, unless you actually seize in the doctor's office, they have to rely on you reporting them. And sometimes they give you these monitors you can wear, but they're just always tough. Social Security just seems to put a hard line on those. The small vein disease, again, what does that mean practically? That's what I would ask you. What does that mean in terms of your functioning? We know you fall a lot. We know you've got some neck issues, but do you have numbness in the hands and the arms? Does it limit your lifting? You're falling. How frequently do you fall? Is it just on flat ground, or do you have to be on an uneven surface? Things like that. Poor balance. How long can you stand without having to move? The seizures, how often do you have them? Are they grand mal, the petit mal? How bad are the seizures? How long do they last? How long does it take to recover? The blurred vision, is it 24/7? Is it just in the morning? Is it based on diet? Is it arise from diabetes? A lot of questions here. The small vein disease, what does that mean in terms of your cognitive capacity, in terms of other functioning? So a lot more questions than answers here. And again, how old are you? Big question. But you can see there's a lot of questions that would need to be answered here for me to really tell you more. Okay, so it sounds like Charles applied for SSDI, because this is what he said before, and got approved for SSI. That must have been your date last insured ran out. You got approved for SSI as of your 50th, I believe is what you said before. But your SSDI insurance had already run out. And I've had this happen a couple of times. It's really frustrating that a judge wouldn't cut you a little bit of a break. But 50 is a really big deal for a lot of judges because the grids do apply. I can't speak to what your attorney did or didn't do. I think that, if you got a partially favorable decision, that only got you approved for SSI, you have 60 days to appeal that. It sounds like it's already run, but you could theoretically appeal that. And I have appealed a couple of those, where I got, my client just got SSI, and if we'd gotten it back 5 or 6 months, it would have been SSDI, probably worth appealing. My lives are way better than Walter's. Oh, well, I appreciate that. Look, I've seen a couple of Walter Knott's live streams. He just has a different style, and I don't judge. Again, he talks about different things than I do, which is cool. And I think he's very knowledgeable. And, you can learn from everybody, just different styles. He's New York, I'm Georgia, so, well, I wouldn't go, it's horrible, but okay. I'm not gonna disrespect Walter. I think he certainly is. Look, anybody who does this is putting their time into the public and trying to give free information, which I think is laudable. And like I said, I think Walter, I've seen some of he's very opinionated. He tends to be a little more about the opinion than I do, but he's done this for a long time, knows what he's doing. So I have nothing but positive things to say about him. Okay. All right, Charles is not happy with Rick Allen's office. I understand. I understand. All right, Jackie, husband has an ALJ hearing next week. A client of mine. Oh, okay, yeah, because I sent him the brief yesterday. Yes, common questions. I will be talking to him, to your husband, Terry. I'll be talking to him probably tomorrow. I wanted him to look at the brief, and we'll go through all the questions. But yeah, we've got the briefs done. I think we're ready to go. And because your email came out as Jackie when I'm like, I'm talking to Terry. What's going on? So I asked him. I said, "What do I have your? Do you go by Jackie?" But he says, "No, it's Terry." But he doesn't do emails much. So yeah, I'll be rather than again. I went through this before. I think at minute 45 or so. But I'll be calling Terry tomorrow, and we'll go over the hearing questions specifically. All right, Christina says, please share the live stream. Yes, please let people know. I would really appreciate it. That is always helpful. I like to get more people on it, just because, again, the more people that are on it, the more interesting it gets, different questions. Okay, yes, Jackie, I believe me, I dove into his file last week, and like I said, we got the pre-hearing brief done, ready to rock and roll. You probably saw it, and I think we've got a pretty good argument here, given his age and given the nature of his medical issues. Yeah, Charles is frustrated that there are a lot of hoops, no question. Linda, how are you doing? I do not think you should have to worry about a review. Stage, I think we've corresponded a little bit. Good for you. You're doing well. Turning 60. You need to worry about a case review? No, I don't think. I think that I suspect that even if you're doing well, you're probably on some sort of maintenance drugs that have side effects. And as long as there's you have some residual weakness, maybe some after effects of chemo or radiation. But the big thing is once you're 60, I mean, there are bigger fish to fry. I mean, there are just more people that would be likely to be reviewed. A person who's 35 or 40, excuse me, pardon about that, than a 60-year-old with cancer. So or hopefully recovering, a survivor of cancer. I don't think that you should have a problem with that. I just think it can be very unlikely. How much does it cost to get a current copy of your e-folder from a lawyer like me? Based on the recent letter, it sounds like I won my case at recon without a hearing. Well, I can't. Only way I can get a copy of the folder would be if I'm representing somebody. So if I'm representing somebody, I just download it. I can get it in like a minute. I just send it to all my clients when they want it. But whether you can get one from Social Security on your own, I don't know. Again, in the the old days, you could make an appointment with your Social Security office, go down there and get a copy of your file. Whether you can still do that, I don't know. I think that they're really trying to go against some of these in-person appointments. But if you can get one, that's what I would do. But I can't do it unless I'm representing you. And if you've won, there's no need for an attorney, really. Okay. Karen says, I'm glad I got you live. I'm glad that you got me live as well. Thank you, Jackie. I appreciate it. Yeah, I think hopefully we're over the worst. Again, a person in their 80s who falls, I'll just leave it at that, is not a good thing. And hopefully we're past the worst of it. So anyway, but we're trying, but yeah, it's traumatic for everybody. Okay. Okay, good question, Shilnick. I think this is I get this question actually a lot. Able to provide my own records, am I required to sign the 827? I'm going to say yes. I think that Social Security, I've been told by Social Security reps that they prefer to get the records for the simple reason that when they get it from a claimant, and even from some attorneys, quite frankly, their concern is that somebody's gone through that record and pulled out stuff that is damaging. Call them cynical or not trusting, whatever you want to call it. That's their concern. I just think you're really hamstringing your case if you won't sign the 827, which is the medical authorization. Um, I just think that if you're going to go in this process, you sort of need to sign it. Um, do you have to? Absolutely not. You don't have to. But are you going to more likely to get denied at the initial recon? Absolutely. You get to a hearing, you're going to have a judge who's going to say, we couldn't get all the records. Why wouldn't you sign the 827? Well, the judge, I'm concerned about privacy. Like, judge, that's not going to fly. So I think, no disrespect, but I would sign it. I think that's going to make things better. Muley says, my appeal for the onset is going to a judge. What can I expect? Well, the judge will, try to make a determination as to the dates of your disability. I've had a couple of these cases I've tried, and all the ones I've had so far, but really the same thing as any hearing. But the judge will be really, because it's if you appeal the onset, you're appealing everything. So you cannot assume that you're going to be granted at a minimum what you were already granted. So you have to treat this like a completely new hearing, a de novo, a brand new hearing for every issue here. Will the judge see that you were approved early? Yes. Is that binding on the judge? No. So you want to be able to prove your entire case. Vince tells me that going to weigh-in is next month. The blood work is next. Okay. Very good. Vince is on the carnivore diet. Currently 59, waiting to apply. There's a tiny advantage to applying after age 60, but really the big break is after age 55. So if you haven't applied yet, I don't know. A, there's no reason to wait. B, worst comes to worst, a judge or a Social Security could approve you as of your 60th. I don't know why I wouldn't wait necessarily unless you're working right now and want to try to continue to work for a period of time. But 55 is the real cutoff, more than 60. So I would tell you to go ahead and apply. Okay, so Muley was approved at initial recon and is appealing the onset date. And I've got a couple of those. In fact, I've got a hearing coming up next month on one of those cases. So yeah, but it's going to be a totally new hearing. All right, so Jen, my paralegal, they've got a name for their team, the Golden Glow for Ginsberg Law Offices, the Gloden Girls. So, okay, I said, which one Blanche? Which one is, what are the other names? I can't remember the names. Rose. Which one's Rose? Which one's Blanche? They want to answer that. So, if you're too young to know what the Golden Girls are, it was a sitcom a number of years ago, starring three women of a little bit older that were, their exploits. It was actually very funny. And B. Arthur, who was Maud, if you remember that, was in it, and who else was in it? Betty White was in it, and there was another woman. Was it Rue McClanahan was in it? So it was pretty funny, pretty funny show. But a lot of people still remember it. Okay. Marie Bledsoe, SSDI website says on my case, your medical determination was selected for a federal quality review. Next 7 to 10 days mean they will make a decision. Yes, that probably means you won. You were approved, and they're going to just review it. So it sounds like we're getting more of these. I'm starting to see more people asking about these things. So we'll see if we see more of that. Okay. Must run. Thanks for invite. Get some rest. Okay. I will try to get. Yeah, you see me yawning. I need to get. Well, it was a nice day. I played tennis the past 2 days in a row, and I played on Monday. Was it Sunday? What's today's Wednesday? So I played Sunday, like 3 sets, and it was pretty intense. Played some pretty good players, and then I guess maybe that was Monday, and then I played Tuesday morning for 2 hours. I was really hurting, and so today I didn't play. I just took a 4-mile walk with the dog. So yeah, I mean, in my advanced stage, I get tired, so I'll play tomorrow. So we'll see how it goes. I have an Alta match or a league match on Saturday, so I like to stay sharp. Okay. I'm the one that told you not to take Benzos or SSRIs just because I'm trying to keep my SSDI. I have two CDRs, one in 2019, one in 22, I'm turning 60 May. I can't, Stacey, I can't promise you won't. I think it's just not very likely at 60. I mean, you could, but I just don't think that's who they're going after. Um, okay, Rajul is 36 years old, back pain and schizo. You were the one asking about what happened to the hearing. Been denied 3 times, first time to have a hearing, denied because they said it wasn't severe enough. I'll tell you, Rajul, the 36 is the real problem, in my opinion. Anybody who's 36 years old has got a really hard time winning unless it's really, really debilitating. Your back pain, schizophrenia has got to be, to the point where you were almost non-functional. That's the issue. You're just very, very young. I wish you the best, but that's going to be an uphill battle. Courtney says, "Thank you. You're welcome, Courtney." Phoenix Rising. Hello, Phoenix, longtime subscriber. Good. First time in chat. Okay, well, welcome. Had a video call hearing yesterday. Felt horrible. Had a legitimate panic attack with antidepressant pressing questions. I major depressive, general anxiety, chronic pain, fatigue. Prior to TBI in 2007. Had a panic attack when the judge pressed my activities in 2021-22. Time which I barely remember. Since the TBI, things tend to blur. Ended up feeling as if I did something wrong, so you panicked. Lawyer to call me after I did well. She didn't see her went well. Again, it's really hard to tell, and I mentioned this in previous live chats. If you can, I know it may be uncomfortable, Phoenix, try to get a copy of the audio from the hearing. It will sound a lot different than what you remember. Just trust me on this. It's going to be a lot different than what you remember. You may not come across nearly as bad as you think it was. And, some judges are not very nice, I'll tell you. Some judges are, they're just focused on trying to make it the right decision. They may press you because they want to see, if you're saying I decompensate under pressure, they want to see for themselves. So they're going to press you a little bit to see what you do. And that may work in your favor. So, if your lawyer felt it went well, that's a positive sign. But I would listen to the hearing and just try to, or maybe have someone that that you trust listen to it, get an objective read on it, because you might be surprised. You listen to your hearing, you may come across as a lot more sympathetic or a lot more credible than you think you did. So don't assume because what you remember is what actually happened, because you've got some mental health issues. Your memory may be a little bit faulty. But I would do that, and I would also rely on what your attorney tells you. But I'm glad you came. But thanks for your question. Matt says MRI to show degenerative disc bulge, neuropathy, fallen over 10 times, false assistant. Yeah, I mean you've got some significant issues there. You're falling 10 times in the last year. That's not just an occasional. That's once a month almost. Sit, stand, sitting for an hour. So you've got and those are very specific. That's what I really like about the way you put it. Very specific issues. After an hour, you're going from sitting to standing and you could fall over. That is a functional limitation that can be applied to a work environment. So that would be very, very helpful. But I think all that sounds very promising in terms of a case. Again, your age being a big factor here. Okay, Eric says, I was denied twice, not good at a hearing. Don't let the being denied twice mean anything. It doesn't mean anything at all. Get a whole new look at it at a hearing. The hearing almost 58, have a herniated disc in my L4-5, 100% disabled, PTSD, which is not binding on Social Security, but you have some limits on no lifting. Yeah, I mean, look at the grids. Look at grid rule 202.06. Go to gridrules.net, put the link in the crawl here, and look at 202.06. And I think you very well may fit into that. I think it sounds like it sounds promising to me. Okay, medium, the highest grade of school complete 11th grade used for direct credit for 3, medium approaching advanced age, limited skill. Okay, so you're citing one of the grid rules. medium, and basically, in fact, we can actually pull up the grids because I know people want to see this. And let's kind of look at it. Let me just move it over here so I can take it on a different screen. I got 3 monitors here, so bear with me 1 second. Share screen, grid rules. Okay, so this is what the grid rules look like. And if you go to my website, I should say, thegridrules.net. So you see here that the grid rules is going to be based on your residual functional capacity. Is it sedentary, which means, again, standing no more than 2 hours a day, light, which is standing and walking 6 out of 8 hours, and lifting 10 pounds frequently, 20 pounds on occasion, or is it medium, which is standing and walking 6 out of 8 hours, 20 pounds frequently, 50 pounds occasionally? If you're limited to medium work, because that's a fairly, that's a lot of weight. There's not a whole lot of grids that really apply. See, the only ones that would apply here would be if you are between 60 and 64 with a very, very limited education. So not a lot of grids apply, here. Now, in this case, 11th grade education would be limited or less. And assuming you're now approaching advanced age, it's not 50 to 54, it's 60 to 64 at medium. So there's a big difference there. So not 50 to 54, 60 to 64. I can probably tell you over the 30-something years I've done this, I've used this grid rule a handful of times, just not very often at all. I use this one a lot, 202.06 in particular, because a lot of people are limited to light work. And if you're limited to light work and you have no transferable skills, then, light work is fairly, it's a lot of jobs require light work. Again, standing and walking 6 hours, lifting 10 pounds frequently, 20 pounds on occasion. So that's not a really intense limitation. But if you're limited to that, you very likely grid out. So 202.06, 202.04, I win a lot of cases on that. So look at these. And I've talked about the sedentary grids. You got to be limited to sedentary. But if you see here, it's hard. You either have to have, very limited education or high school grad and unskilled work or no transferable skills. But you got to be 55. It's harder to win. So the grids always are going to work better if you're 55. But at 50, you could win on the grids. But you see, there are only a couple of instances here. High school grad, this is the one I see the most, 201.12. You're a high school grad or more, no transferable skills, and unskilled work background, or semi-skilled and not transferable. That would be someone who's 50 to 54 would meet the sedentary grid here. These are the two you're going to most likely beat, 201.12 and 201.14. It's just more people fit into the light grid. So that's why, to me, 55 is life is a lot easier at 55. Okay. So, but take a look at the grid rules. That's where to look at it. Okay, and Karen's the one with a number of different things. Basically, dementia, family 54. So, you've got a lot of things going on. The small vessel disease. Realize it can cause dementia. Are you having memory, processing, cognitive issues? The fact that something can cause dementia doesn't mean it will cause or has caused. So, again, this is really about what's going on in terms of your function, not what could happen down the road. It's what actually is happening. Megadog, 68 on Social Security. I like to work these part-time. Can I work anymore? Can I get supplemental? I don't think so. Again, I can't comment on this. I'm not sure what supplemental DI means. SSDI, if you're on retirement Social Security, that would, there would be no disability. So nothing jumps out at me. I'll just leave it at that. Do I recommend hiring an attorney initial recon? That's totally a judgment call. I mean, do you absolutely need an attorney? No. Straight, you don't need an attorney. people will sometimes bring me in early for a couple of reasons. One is they don't want to mess with filling out these long forms, the application. They need some guidance about how to fill out the activities of daily living, the adult function report. We offer guidance for that. I don't fill them out for people because it's evidence, but I can offer guidance on it. We can submit things electronically. We can access your file and get copies of records. For some people, it's worth it. Other people want to give it their best shot. I'm not offended either way. But it just depends on how much of the process you want to deal with on your own, or do you feel like it's just overwhelming and it's causing you a lot of stress and headaches? Then bring an attorney in. It just really is going to depend on you. I would definitely have one at a hearing, but at initial and recon, that's a judgment call. Some people think it's really worth it. Some people say, well, I don't want to give up a big chunk of my past due benefits for someone to fill out some papers. But again, if you wouldn't fill them out correctly and I would, then it's worth it. So it just depends on what you feel that you feel most comfortable. Yes, I'm talking about Walter, not yes, exactly. Phoenix is only 38. Realize mental health conditions, I'm probably less concerned about your age with significant mental health issues because age is really not a factor there. But, it is overall a factor, but not, a back injury at 38 is going to be much harder than a back injury at 55. A severe mental health problem at 38 is going to be kind of analyzed the same way as it would be at 55. So I'm not quite as concerned about age at that point. How long between short? I'm not sure for. I don't think. Okay, so are you in the? I don't think you're ever in the clear. But the fact that you've got a short form, you haven't heard anything since October. That's a pretty good sign. Okay, so Phoenix Rising had the TBI. I should have gotten help earlier. Yeah, again, people say that to me sometimes. And look, there's nothing wrong with trying to work. Absolutely not. But if you look back and you say, I was really not very functional, not very capable, and I should have gone for this earlier, but you can't change that. So you got to move forward. Can't go backwards. Nerve root compression is always serious. That's always serious. Yep. Look for that MRIs. Rebecca, yes, we did win. Excellent. Thank you. I appreciate your kind words, Rebecca. I'm glad we won. It's always nice to see when I get this little status report when I see, an approval. I'm like, that's great. I love to see that. So absolutely. Let's see. It was early this month, April 3rd, when we got the favorable decision. So yes, I'm glad and thank you for tuning in. I appreciate that. And again, I'm thrilled. I'm really thrilled that we won. It's always when I look up every morning and I see fully favorable, like that's great. That's what I want to see. See more of those. Hello. So No Sky, my buddy Garrett says he thinks that Jen is the Dorothy character, the B. Arthur character. So Jen, if you've not looked up B. Arthur and Dorothy on the Golden Girls, you should, because that's what Garrett thinks you are most like. So I will not comment. I'm going to keep my mouth shut. Yeah, I know it's stressful what the judge is going to decide. There's no way to know, and it is stressful. Very, very stressful. I get it. Michael, yes, I'm looking forward to winning your case too. That is absolutely, you definitely want to have, I always go in every case I take, I think we have a good chance of winning. So that's the attitude you got to take. And again, it's, winning is the word we got to use, but it's just getting what you deserve is really what it really means, more so than winning. Chill Nick, thanks for answering the question. You are very welcome, Chill Nick. Teresa has a hearing next week. I'm scared. Yeah, just do your due diligence. Prepare. Look at videos. I got a bunch of videos about hearings. Evidence is good. You should be fine. Just tell the truth. Tell your story. I've said this before. Just go into this hearing with the idea you're going to tell your story. Your starting point is, I don't want to be here, Judge. I hate the idea of filing for disability. I've worked my whole life. I was financially self-sufficient. I helped my family. I felt good about myself. I enjoyed my coworkers. I enjoyed the people I worked with, served, and so forth. I hate this, but I can't work, and here's why. This is what happened to me. And every time I've tried to think about go back to work, this happens. And I have these very, very specific problems. I can't sit for more than 10 or 15 minutes. My back seizes up. I can't stand for more than 10 or 15 minutes. My back goes into spasm. I'm spending my day, trying to get comfortable. I'm in a recliner for 4 or 5 hours a day. They've given me, Neurontin. They've given me, Percocet, and I take these medications and I'm a complete zombie. This is depressing. I've been talking to a counselor. I mean, you tell your story. Like, I don't want to be here, but this is where I'm at. But judge, if I get better, if they can do a surgery, if there's something to be done, I will be back to work in a minute because I do not want to be like this. I don't want to be collecting money from anybody. I want to be self-sufficient. And, I've got a long life ahead of me and I have a lot to do. That's the way you got to approach. Yuli, you're welcome, Yuli. Phoenix says, my lawyer thinks, well, again, like I said, Phoenix, listen to the hearing, talk to your lawyer. But, I think if your lawyer felt it went well, then that's a really good sign because, look, I will tell you, there are times when I have hearings and I don't think it went well. My client didn't answer the questions very well. The judge was clearly hostile, whatever it may be. And, I'll tell my client, look, this did not go as the way I wanted it to go. And here's why. You still could win, but these are things that concern me. And so I start laying the groundwork that we need to appeal this. So, absolutely. You can appeal it if you have to. Carrie, hello, says hello to Jen, one of Jen's fan club there. Yes, very much so. Can my MD fill an RFC? Yes, some kind of number. I mean, these forms are available. I think I used to put them on here. I mean, let me get you an example of one. Free residual functional capacity forms. Okay, so I'm going to put that in the comments here. Here's some free forms. An attorney offers them on his website. And again, they're not customized, but they're free. So yeah, your attorney can and should fill it out if they will. Is it normal to feel you've done? I would say normal to feel something you've done something wrong. You can feel stressed. I mean, the judge is representing the commissioner of Social Security, and some judges are a little more diplomatic or pleasant than others. Look, I remember there was a judge here in Atlanta who's since passed away, and he had no personality at all. He was just not like a stone face. You couldn't read him at all. And he could be downright rude to claimants. He would cut them off. He would, remember one time he got mad at somebody because they said, damn. He would stop the salty language. Okay. He was just just not a very pleasant person. This guy had a high approval. He would approve cases I was surprised he approved. Just never know. You don't know. The demeanor doesn't mean anything. There are judges that I know that are just nice as can be, pleasant, sympathetic, very, they seem very empathetic, approve 25, 30% of cases. It just depends. You just don't know. So, I think you just need to wait and see what happens. But again, listen to that hearing. Rick Newman had my court case 3.5 weeks ago. His latest ever time. I'd say, 4 to 6 or 7 weeks is pretty typical. Teresa's 51. She's got the hearing coming up next week. Chronic lower back pain, medical source sent for the doctor, missed 3 or 4 days. Yeah, that's a winning. That's the 51. It'd be better if you were 56, but 51 is still pretty good. I think that you probably meet one of these grid rules, or that your functional capacity is less than what would be acceptable in any job. Missing 3 or 4 days of work, being off task 25%. That's a winning. If the judge accepted, that's winning. That's winning. Who would I ask? Who would you ask? What, Phoenix? I think your lawyer is the person. Oh, as far as the audio, yeah, ask your lawyer. They can download it. It's available. It should be available within a day or two, and they can download it for you. If I receive a CDR this year, aside from reporting mental health issues, should I also report new COPD, asthma, and Sjogren's? Yes, absolutely. You should report the new things. Teresa, diagnostic. Yeah, you've got either a disc herniation, or you've got a severe bulge, or you've got an annular tear, something like that. Yeah, you've got a good case. I think it sounds like it's very promising to me. Okay, another Golden Girls. Estelle Getty and Sophia. Sophia I think, is that Blanche's mom or Dorothy's mom, I think. And actually, trivia, Estelle Getty was the youngest of all those women, yet she played the oldest one. And she played Sophia, who I think was Dorothy's mother. And as Sophia, she had a little bit of a touch of dementia, is the way they wrote it. But it was very, very funny. It was a really clever show, and I think it was. A lot of people thought it wasn't going to make it because you had these older women. They were all in their 60s or older, as stars of a sitcom. But it was actually very, very clever and very well done. It's been off the air for many years, but you can catch it on YouTube and so forth. So if you haven't seen it, it's definitely worth a look. It was a very funny show back in the day. Okay, Matt. Thank you, Matt. Appreciate the recommendation for the 5 stars. Much appreciated. Thank you, and good luck with your case. When you file for, again, SSI and SSDI are 2 different things, Ty, so make sure you talk about the right thing. If it's SSDI and you work part-time, it used to be I would tell people not to work part-time, but now, $1,620 a month is SGA. I'm telling people $1,000, $1,200, $1,400. Social Security realizes people have to eat. So I don't think it's as big of a deal as it used to be. So I would tell you not to sweat it working, but just be aware of that $1,620 a month for SSDI, or for the SGA rather. Okay. So Tommy received, it looks like, the short form. Does your doctor think you should work? Should you expect a follow-up? Probably not. I mean, you're 50 years old. You've been in Social Security for 3 years. Normally, those short forms are graded by computer, and if you don't hear anything pretty quickly, probably not going to hear anything for a while, if at all. Okay, Strawberry Shortcake Memories was approved for disability before 40. Okay, very unusual, but good for you. First time denied, second time to reapply without legal assistance. I advise to keep up with your doctor's appointments, which is important. I have a certificate college education. YouTube videos help me. College education and services. Okay. I think all these things are very, very relevant. And again, it just shows you can, if you're diligent, you can win. Madeline, good night. Good night, Madeline. Thanks for stopping by. John Doe was told by the attorney not to take SSI cases, but won't pay more, 20 more, so no pay. Okay. So SSI is obviously much more limited fee-wise than SSDI because, A, the amount of your SSI benefit is limited to like $1,000 a month, a little bit over that, whereas SSDI is often, $2,000 or $3,000 a month. We're getting paid a percentage of that, so obviously you're going to get paid more in an SSDI case. Secondly, there's no look-back period. For SSDI, you can go back a year prior to your application date. SSI, it's only as of application date. If you want to get paid more than 25, now the back pay will not be the issue. The problem is if you have any assets or other source of income. So, the back pay represents prior months. That's not the issue. But if you have any kind of income, even a small amount of income, that would offset your SSI. But the attorney will get paid for an SSI case, assuming you don't have any source of income or any kind of assets. I will tell you, in reality, that can be a problem because people sometimes don't report what they're getting, and Social Security will, ask them, and then they acknowledge it, and then there's no past due benefits. So yeah, it's harder to find an attorney to do SSI cases than SSI. Absolutely. Okay, gave it a shot on his own. The judge stopped your hearing and said, get a representative to navigate you. I mean, that just shows the judge felt like you needed some help. And like I said, I had a case like this that we just got an approval on, although not a, it was a closed period, but it was still an approval. But this is the judge stopped the hearing and said, you need to get an attorney because there's some unusual issues here. It just means the judge wants to do the right thing. So that I would say overall, it's a good sign. Okay. Chan, so we have a reconsideration. How long does it take to get a recon? It's going to be 8, 9, 10 months. August of 24. You may not hear anything to May or June or July of 25. It's just way backed up, way back up. Michael is 59, severe. Let me go back to your original comment here, Michael. Where you are. Huh. Okay. Severe osteoarthritis in the left knee, gout in the left foot, blood clot in the right leg, osteoarthritis in the right knee. I think, let's see, I just saw, there you go. Okay. Yeah, no, I mean, you can see why I took your case, okay? Because you've got, you're over 55, you've got knee problems and gout in the left foot. So what does that tell you right away? Grid rule 202.06, I would think, could be an issue as long as there's no transferable skills. A blood clot, those are very serious. Osteoarthritis in the right knee. We want to get your case approved early. That's the goal. That's the goal here. But you got a lot of stuff going on, and yet you meet the I mean, your case to me is this very strong case, which again is why I took it. I'm thinking it's fairly new because I don't see it. I was just looking here. I'd say sometimes I don't know which way I'm coming or going here. Because like I said, this has been kind of a crazy week. Crazy week. Okay, Michael, I'm just looking you up just to see initial app. So we just okay. So we're only a couple months in. So yeah, we're going to try to get you approved early. I hope we can because you deserve it. You definitely deserve it. And I think that I'll do my best to get you approved early. I can't promise you, but obviously we're going to do our best because I think you are one of those people that is clearly deserving and should be approved early. Okay. Okay. Your doc says you cannot work, so can't work. That helps. That helps. My pleasure, Tommy. Okay, this is a question about the grid rules. How would a Bachelor of Science 4 degree hurt chances for 20 years in IT with gout? Okay. 51 years of age, chronic gout for 10 years with all the evidence. Okay, I think that JR realized that, first of all, gout is a condition that I think every judge realizes. When you have a gout attack, I mean, the level of pain you're in, I don't care. You could have 15 degrees, college degrees. It's not going to make a difference. When you're having a gout attack, physically, you're not going to be able to do anything. And because of the pain level, you're not going to be able to do anything. I don't think the 4-year degree is going to hurt things at all. And if you look at the grid rules, it only makes a difference between high school education and less than high school education. So a 51-year-old with chronic, gout that's not being able to be treated properly. I'm assuming you're on allopurinol and other preventatives. It's not really helping, but you're having these, chronic, constant attacks. And again, the frequency is really important of how often you're having the gout attacks. I think that you've got a good argument. Okay, 51 or 41 or whatever. If the evidence documents you're having, uncontrolled gout attacks, no matter what your age. But at 51, I think you've got a grid rule argument. I think you've got a functional capacity argument. So I think that your education will not hurt you in that regard. People think education hurts them. The way I look at it would be it's more that a lack of education makes your case stronger because they realize that people with a 8th grade education are going to have a hard time finding work. So I think it's more that that's going to help you as opposed to having a college degree is going to hurt you. They don't punish you for having a college degree. They just assume that you have maybe more capability. You could do something else. That may be, and so if you want to call that hurting your case a little bit, but the way the grids are designed, I don't see it as a negative really. Relax, has 3 strokes and embolism, nerve compression. Yeah, you got a good case. I mean, I can tell you right there that's a good case. Michelle says, "I want to thank you for my Michelle, thank you for commenting. Information Chevrolet got approved at Recon. Great, excellent. Onset date November 24. Good for you. That's what I want to hear. I mean, that is always a good thing. Again, if that's been helpful, leave me a review. Absolutely. But that's good. You know, it's always good to hear because getting benefits can really change people's lives. Okay, got a couple more questions here. Afsena, like I said, I owe you a call, I know. Yeah, you're in. Okay, JR's on allopurinol, 600 milligrams, heavy dosage. Jerry, one of my clients, quick thanks, appreciate it. Okay, good. Absolutely, Jerry. I appreciate you. And GR Gomez, King G, it says here, learning from you for YouTube videos. Well, good. I hope the YouTube videos are helpful. You know, I put them out there to educate people and just, you know, this is confusing. There's no question about it. So I hope these are helpful. And I appreciate everybody who does find them useful. So again, if you do find it useful, leave me a comment. And if, like I said, if you wanted a case evaluation, please let me know. That would be awesome. All right, let's see if I got any more. Okay, I got a couple more here. Oh boy, after 2 years, the benefits went to the wrong cat. This is where, Ty, you need to contact your U.S. Senator or representative. I think that would be really helpful because this is a technical problem. Okay, Eric Webb, herniated disc, therapy, health. Yeah, I think again, solid case. Guitar Gardens, heart attack, stents. Yeah. I mean, you don't say how old you are, Guitar, but all these things, you know, are significant medical problems. Again, you don't win based on the diagnosis, but I think that the underlying medical, it sounds like it probably would produce functional issues. I love me. Okay, 56 degenerative changes. Yeah, that's a solid case. Relax YT. Yes, absolutely. You see this contact thing, just email me and let me know that who you would just say, I'm Relax YT from the live stream, and we'll get right back to you. Guitar Gardens is 51. Heart attack. Yeah, I mean, that's 35-year work history. That's helpful. Again, solid case. I think it's a very solid case, assuming that you are having ongoing issues arising from the heart issues. You know, I mean, are you having shortness of breath? Are you having difficulty? Do you get fatigued easily? Do you have medication side effects? Things like that. But otherwise, it looks pretty good to me. Okay, we are now at 2 hours and 3 minutes, and I appreciate everybody who's here. Again, if you celebrate, I hope you have a very happy and meaningful Easter this weekend, and we'll see you again next week, next Wednesday night at 8:30 Eastern. Thank you much. Bye-bye. And like Christina says, please like, share, comment, and subscribe. Absolutely. Take care, everybody. Good night.